Hello, Julie. Thank you very much for participating in this series and for being here today. Julie Johns is a criminal lawyer, and I'm going to hand over to you now, Julie, to tell us a little bit about yourself.
Thanks, Paula. It's really good to be here. Thank you for having me. So I've been a criminal defence lawyer since 2010, just practicing exclusively in crime and defence. I started my career working for Peter Hamill, Senior Counsel at Forbes Chambers, and a lot of other incredible barristers. And Peter Hamill is obviously now a Supreme Court Justice doing an incredible job. That gave me an amazing insight into Court of Criminal Appeal matters. So that is one of my specialties now. Since then, I have worked at various firms practicing, as I said, exclusively in crime. So it's something that I have a real passion for and something that I plan to stay in because it's something that I think has been something that I've dreamed of doing. And yeah, it's an incredible opportunity and privilege for me to practice.
Thank you, Julie. So as a criminal lawyer, you act for the accused. Is that correct? Can you help people understand how the criminal system works?
Yeah, absolutely. So when somebody is first arrested, they will be either taken into a police station or they can get a field can, which is a court attendance notice. So that's a can. They'll be given a set of facts that the police use. So when they're arrested and they're given the opportunity to find out about the charges, they will be allowed to make a phone call and they will give us a call. So we will get calls at all hours, weekends, evenings, or you'll have a family member call you in the middle of the night. It doesn't matter. So you're absolutely ready for that at any time. Obviously, people are very scared. A lot of the time, they've never come into contact with the criminal justice system. So a lot of my clients, no matter how serious the charge, have no idea what's happening. So after that process of being arrested, they're offered the opportunity to be interviewed. And then after that, if they choose not to be interviewed, they would be assessed for whether or not the police will give them bail, which is called police bail. And then the next step is if they don't get police bail, that they will come before a magistrate the next day or as soon as possible. So a lot of the time we will be called to make a bail application, and we'll speak to somebody in custody in what's called the cells at a police station.
So when people get arrested, are they almost always asked to do an interview?
Yes, unless it's so for instance, if it's a drink driving charge, they will be picked up on the scene and they will be given either a field can, which is that court attendance notice, and they will be told to appear in court at a certain day. If they need to be taken into custody and they're under arrest, and under arrest just means that they are not free to go. It doesn't mean that the police have to say you're under arrest. They are just unable to leave, and that's made clear by the police. So once they are arrested, if they are arrested, they'll be taken into custody. At that stage, they're given an opportunity to talk about the charges with the police. That's called an ERIS, which is an electronically recorded interview. And that's recorded. There's two police officers sitting with the client. They'll be talking about what the charges are, and they're given a right to respond to those. Of course, people have a right to silence. They do have the right to say, I don't want to speak to the officers about this. However, that gets a little bit more complex. It's probably a little bit more complex than what we have time to go into today, but there are issues of what's called a special caution that can be given if somebody's had legal advice and the solicitor is present with them. That means there are different obligations, and it means that it could give rise to issues such as why that defence wasn't raised and why reasons weren't given at the time. That can be relied upon later, as in the failure to explain what has happened and to give detail to the police, if it's relied upon later. But those are only in circumstances of the special caution where that was given. So for those reasons, we wouldn't usually attend a police station now because that gives the opportunity for the special caution to be given. If we do attend a police station, we certainly wouldn't want to be put into a situation where we haven't been given a brief of evidence and we haven't given full advice to a client. So usually it's a situation where we'll speak to a client in the police station and we will give some advice, but it won't be a full kind of assessment, because we haven't been given enough evidence at that stage to be able to give a full advice.
So let's just say a person is unfortunately arrested for whatever reason. They're taken down to a police station. Should they, or is it advisable that they talk to a solicitor before they answer any questions? Or what is, because I think a lot of people would prefer to remain silent and to consider their situation properly than to make statements which could be taken as admissions later on. So,
You're absolutely right.
So what is your general advice to people who would end up in this situation?
Yes. Well, we also can't give advice in the exact situation without seeing facts, because maybe there is good reason to say something. Generally, we would advise not to say anything, only because, as you say, when people are arrested, a lot of the time they've never been in that situation before. They're terrified, and sometimes what they say may be misconstrued. So giving advice to somebody when they've just been arrested, if I don't know enough about the case, for instance, I would advise them to not say anything. There's a little bit more, as I say, a little bit more complexity there, but generally it's a good idea to be well aware of what you've been charged with and what your rights are, and to have a chance to talk to a solicitor before you would say anything in an interview.
Is a citizen legally allowed to invoke the right to silence?
Well, we don't have necessarily, it's not like in America where you've got that constitutional right, but it is a situation where there's protection for people not to have to speak. But as I say, it's gotten very complex, and I think that a lot of solicitors are not aware of this special caution. So particularly solicitors that don't act in the criminal law field find that whole area a little bit new and might not be aware of those obligations. So I think it's definitely important that somebody speak to a criminal solicitor if they're arrested, someone who specialises.
Right. So as soon as that event happens, to seek the advice or the assistance of a criminal lawyer is recommended.
Oh, absolutely. Even if someone's pulled over for a drink driving matter, it's definitely a good idea to give somebody a call, because even if you haven't been arrested, you need to know what your next steps are. There's all sorts of things that flow from being arrested, and there are pieces of evidence, for instance, that you may not know you might need. For instance, if there's a defence to be raised, there's all sorts of issues such as CCTV footage, which may not be kept for very long. Sometimes it loops over itself. Sometimes there are other issues about witness availability. There are things that a solicitor will tell you that you may not be aware of.
So, Julie, obviously, when people are involved in criminal law trials, they want them to finish as quickly as possible because it's quite a stressful time for those people. Can you tell me what impact COVID has had on the timing of criminal trials?
Absolutely. It's a great question, Paula. So at the moment, COVID has had a massive impact on the court system, both local court, district court, Supreme Court. So in the local court, if something was listed for a defendant hearing, all of those matters have now been cancelled and they've been delayed. So the last 2 months of lockdown, so July and coming up to the end of August, all of those hearing matters, which means any matter that has a witness involved, those matters now need to be put off. And usually they will be given a mention date, not even a new hearing date at this stage. The local court's been doing an amazing job with it, but it is such a huge impact. Obviously, clients are struggling, and it's a time when we have to spend a lot of time hearing about how scared people are and how much of an effect this is having on their lives. So not only are they struggling with the issues of delay, They're also struggling, if they're in custody, with staying in custody in a shocking situation where sometimes people are not vaccinated. There's obviously the custodial situation is less than ideal for COVID because you've got people in a very confined space, and it is a very difficult situation to be told your hearing has then been put off. So moving up to the more serious matters, in the Supreme Court, I had a arraignment this morning for a murder trial that's upcoming, and we've been told that our trial date will most likely be next year, perhaps May or June. So you can imagine if someone's in custody and they don't have a very good chance of bail, because obviously it's a very serious offence, and in these circumstances there's lots of reasons why someone might not get bail, but obviously people in custody are very scared at the moment, and it's just a very difficult situation. There are, of course, some matters that we can deal with very quickly. So in the local court, if there's a sentence matter, we are doing our best to continue on with those matters. But obviously, any jury trials, they're going over. So it's becoming very, very difficult for people to manage. And I think that it's going to have a flow-on effect in terms of mental health. I'm getting clients calling from custody just really, really scared about what their futures look like. And so we're just spending some time at the moment. I'm having long talks with people just to make sure that they're doing okay and they understand what the process will look like. So I think at this time, our role really is about making sure that clients understand exactly what it's looking like as soon as we know, because the local court's been very good about putting out information. There's a local court memorandum that the Chief Magistrate has put out, and he keeps updating that. So as soon as we know, we like to keep in touch with our clients, because sometimes it's the worst time of their lives. A lot of the time, they have never come into contact with the criminal justice system, and they need someone to explain to them what's happening. And in very simple terms sometimes, because they've never been in the situation before and they're scared.
Okay, got it. And is the government giving any priority to vaccinating prisoners at the moment? So
look, I can't speak to what correctives are doing, but I can say that I've spoken to a client this morning, for instance, and he was not vaccinated. He was waiting his vaccination. And so the effect of that, if you're in a small cell, you don't have a lot of time outside. The repeated information I'm getting is that people are just very, very scared of getting COVID. There is a 14-day period of isolation when people are first arrested now. So they'll go in upon arrest from outside in the community. They'll spend 14 days in strict isolation. The difficulty with that is that a lot of the situations with that has been that we can't speak to the client for those 14 days, which is even worse, because in terms of giving advice on bail and just about their matter in general and updating them, it becomes very difficult to have contact. The AVLs, so that's an audio-visual link, is usually how mentions are carried out at the moment, or over email, but it's very difficult to get a conference time, really long delays, 2 to 3 weeks to talk to a client.
So when are these people put into 14-day isolation? That's not, for what type of an alleged offence is that?
So anything. So anytime someone's coming into the prison system and that they are going to stay in that prison system for a period of time, they will be in that 14 days quarantine. So that means that they're kept away from everybody, which is for the protection of everybody else, but they're not able to speak to us in most circumstances.
So is it to protect the alleged accused, or is it to protect the other prisoners? What's this 14-day requirement? What's driving that?
Yeah, it seems to be from protection of people who are already in custody. It seems to be that it's pretty frightening to have somebody come in from outside. They don't know the situation, but I think it's probably both ways to protect the person coming in, but mainly for the population. It's a pretty vulnerable population in that.
Obviously, at the moment, solicitors are not going out to prisons to meet with clients. Is that correct?
Absolutely. So we don't have any access to clients at the moment. So we're just making do with audio visual link, like we're doing now, and also on the telephone. But families can't see their loved ones either if someone's in custody. So it just makes the whole process even more difficult. They've got no contact with their family face to face. There are phone calls, and there are, this sort of situation. But the problem is when you're on your own and you're terrified, I think they're struggling.
Do you find that most solicitors and barristers who act on criminal matters tend to do that exclusively, or do they also handle commercial matters? What's your experience?
Yes, I have to say that criminal solicitors generally tend to just practice in the area of crime because it is such a specialised area. We tend to know each other, and you also need to know the barristers that you're briefing for the more serious matters. You need to get a good idea of who is good for a particular matter. So some barristers are incredible with appeal work, but maybe not as suitable for a trial matter. Some people, when you see them in front of a jury, they're just incredible, and you'd want to put them into those matters. But for that reason, I think it's really important that people specialise in crime. It's a different kind of field because a lot of it is about how you are on your feet and answering those questions. Cross-examination is another very big one, a very, very specialised area, and something you have to do well.
Do you find the work rewarding, or do you find it overly stressful, or how would you describe your experience of being a solicitor that specialises in criminal law matters?
Look, I think it's one of those jobs where you can either compartmentalise the information that's coming in or you can't. And I think that it's something that you need to be good at, because otherwise you couldn't do your job. So a lot of the time I'm seeing photographs, footage, I'm hearing about incredibly distressing things, but you need to be able to separate that. The other really distressing thing is just that personal, emotional element where you've got people that are facing, if they're on trial for murder, depending upon what they hear in that moment, a guilty or a not guilty verdict, that person's life is truly going to change. It's an incredibly emotionally charged moment. Part of your job is to certainly be there for them in a legal way, but also you need to understand and have some empathy for that position that they're in. The other situation is family members. I think part of the job is definitely trying to help them to understand what's happening and to give them some support at the same time, whilst also doing the legal part. So I think it's one of those jobs where I've always had a passion to do criminal law. I always wanted to help people, and this is the way I found that I can do that. But I also think it's one of those jobs where you need to really take all judgment out of the role. So I think it's suitable for some people, and other people perhaps might be better suited to say, maybe not defence, maybe prosecution. And there's definitely an element there where sometimes you'll be defending somebody and you think what they've done is horrific, but you really need to be doing your job and advocating for them, because you may be the only person who is. And if you're not fighting for them, then you're not doing your job. So I think that it can be a very challenging job. You're getting phone calls at all hours. You're giving advice to people who are incredibly distressed, frightened, and it's a difficult job. It's not for everybody, but I think if you've got a passion for it and you really want to help people to, have their rights protected, which is really what we're doing. And you can take the judgment out. I think that, it's a terrific role to be in. It's a great privilege.
Okay. So, Julie, how do people find you, for example? Now, you mentioned earlier about a drink driving charge or a situation like that, and that you would, even on a charge like that, recommend that these people speak to a criminal lawyer to understand their rights. Is that correct?
Absolutely. Yes.
So how do they find you? Are you on Google? Are you on the internet? Do you have a phone number that's available that people can call? Like, how do people get in contact with you and other criminal lawyers like you?
Absolutely. So the Law Society has a fantastic site to find our details. I work for Rivera Legal, so our firm has referrals from Legal Aid. So I've been on the Serious Crime Panel, General Crime Panel, and the Indictable Panel, which have all now changed their format, but I've been on those panels for a long time. So Legal Aid will send me work from a panel, and then other times I'll get referrals from people in custody. So they will, somebody who I've represented, and they'll say, look, can you help out somebody else who I know in here? And that happens often. And also somebody may be arrested for a drink driving matter, as we talked about, and then I'll get a call from referral. But if somebody needs to find somebody, I would suggest the Law Society website, and Legal Aid also is good in terms of assisting to refer them on to us. So we can do matters for Legal Aid on a private basis.
However, often these incidents would occur and people would need someone immediately, and they could occur at any time of the day or night. Are those websites helpful in that at these random times?
They do have mobile phone numbers. For instance, I have a phone that is, and whether or not this is wise, but I have a private and a work number, which is the same mobile number. So I am always available on my phone because that's what you need to do. People get in trouble at all times. So I have a phone number so that if I get a call, I'm available to speak to somebody in custody, or we get in touch with people certainly through the mobile phone, or a family member can give us a call.
Right, and is your phone number on the internet as well, so that if people did do a search, they would find Julie Johns, criminal lawyer?
It is. So it's on our website, a Rivera Legal website, and also under the Law Society website, and my mobile number. So definitely the best option to get in touch with our mobile.
So it would be to go to the Law Society website for a criminal lawyer. Okay. At this point, I'm going to segue into our other part of this interview series, which is talking about your fashion style. So, Julie, can you tell me or describe to me what it is you are wearing today?
I'm wearing what I would want to call it this morning. So I'm wearing a suit jacket, and I'm wearing a blouse, and I'm wearing some suit pants as well. So that's pretty much our uniform. I spend a lot of time in jails, not now with COVID, but usually I do spend a lot of time in jails. So I've found over the years best not to wear a skirt. So I used to have a bit of a uniform over high heels, but I remember that Parklea Jail stopped us from wearing high heels a few years back and took away the earrings. So we can't do that. So I have to say, in terms of our style, in terms of my style, it's certainly something that is very professional for court, and something that is very practical, given that I go through a lot of scanners either at the court or I go through scanners at the jail. So it tends to be less jewelry if I'm going to a jail. We're not allowed to take, obviously, phones in. So we tend to be quite simple. I do like to have the pretty shoes though, Paula. So I do like to have something that is very, very cute or makes me happy. So if my shoes are making me happy, that's and I can't wear anything else, they don't let me, that's helpful.
So that's your form of expression.
Absolutely. So, and I think that it's one of those things that they never let you down, looking down at your shoes, because, they're just, I'm a big fan of, obviously the practical Nine West kind of shoes, but I'll tell you what, that's probably where most of my money goes.
Okay. Do you actually have any shoes on that you can just show us of interest today or not?
I do, but they're very sparkly.
Come on, show us your shoes. Wow. There you go.
Yeah.
So you've got this.
So we've got. So, I think particularly around the office, which is where we are today, you definitely want a little bit of sparkle in your life, particularly when you're dealing with some of these more serious matters.
Well, that's interesting because I do have this perception, as I'm sure a lot of people do, and particularly anybody that's around the criminal courts, that there's almost an unspoken uniform of, well, dark colours.
Yes. I would agree with you. Absolutely. Absolutely.
Do you, in fact, there are court rules in that regard as well. I can't remember them off the top of my head, but I'm pretty sure that you're, I think that actually now it's coming back to me. There is a prohibition against bright, glary colours in court.
Absolutely. There are, and also that we have to wear a suit jacket. We do have to wear a suit jacket. We don't want to. Sometimes it's extremely hot. We don't want to. But I absolutely. And there've been times when I've forgotten my suit jacket, and I'm sure we all have, and had to run back because it is a serious rule we have. But look, I have to say, in crime, sometimes you really do have to. You'll get this call and you'll have to run into court. You have to do the best you can. I remember I've appeared before with. I had my shoes in my bag. I ran to court in flats. And I remember I had two shoes that were completely different when I put them on my feet. So I had one that was a high heel and it was velvet, and the other shoe was completely different. So, and then they were both, unfortunately, the left feet. So I think that in crime, you tend to think, look, I'm looking after my client. The client comes first. I'm just going to have to get through this. It's not about me. I think that crime's a little bit more practical, and I think that we tend to just go for something that we can, as I say, jails are probably one of those places that they're very strict and they stop you from wearing the highest of heels that you'd like to wear.
Well, you probably, you probably would want to wear your flats in a place like a jail. I don't know, just to be mobile, to move around quickly or exit if you had to. Well, that was very interesting. Thank you, Julie. And I did really like that idea of, even if your clothes have to be really conservative and serious, that you can have a pop of some expression with shoes, or, I don't know, maybe a handbag.
Yeah, nail polish. Yeah, so sometimes you'll have a little bit of expression in there. You're right, because it's a serious job and people are, having a hard time there. And I think sometimes if you can sort of keep that positivity as well and the optimism, and sometimes it's something like your shoes that bring that. It's a hard time with COVID, and it's a hard time in general in crime. I don't think anybody is in a criminal court because they want to be there. A lot of the time it is the worst day of their lives ever. And there's a lot of victims there as well. There's a lot of people that are just struggling, and if you can keep that positivity up and that support, and whatever does that for you, usually it's a bit more serious than what you're wearing, but certainly it helps me. Sometimes you get up and you think, well, at least my shoes are cute.
Yeah, great. Now, Julie, is there anything else that you'd like to share about any matters that you're working on at the moment? I mean, obviously you can't give us confidential details, but maybe just a quick description of the range of matters that you're involved in over the last, say, 12 months. Some examples of some work? Yeah,
absolutely. So we do everything from stealing matters, or drink driving, or drug driving, all the way to the more serious break and enter. So we've got some serious take detain, those sorts of matters at the moment. And the other thing that I have a special interest in is mental health. And so sometimes we will run matters under what used to be called the Mental Health Act, so forensic provisions, Section 32s. That whole regime has changed into a new regime. And so that's the kind of thing we're now governing. So a lot of those matters I have in court at the moment are still under that old regime. And so what that means is that we're trying to divert the client out of the criminal justice system. So we will look to getting a psychological report and getting someone assessed, and then looking at the nexus, so the link between what they're experiencing and the offending. So in situations where that might be appropriate, it's really helpful, because then you're able to get somebody some help. They can get a treatment plan, they can continue getting the help they need, and that means that obviously the community is helped as well, because if someone's getting help, they're less likely to reoffend, and then it means there's no criminal history for somebody that probably shouldn't have had one anyway. Yeah, so those kinds of matters, we're getting a lot of that kind of content at the moment.
Okay, and you were also involved in a murder trial, is that right?
Yes. So this morning we had an arraignment for a murder trial that's upcoming. Obviously can't talk about details of that, but it is one of those matters. Murder trials don't happen quickly, and the actual trial is usually very involved. So there is a lot of work for that. So we have boxes of briefs that we need to go to, a lot of audio, visual material. It's a lot of work, absolutely. So you need to really know that brief inside out for a matter like that. So really a really busy time at the moment. But obviously getting instructions from the client is really important, and having a great relationship with your client where they feel comfortable asking any question, because we do this every day, but the client won't know exactly what's going on. So we've got that contact happening. But it means that obviously these things take some time, and you've really got to give that effort in, particularly with a matter like that.
And Julie, just out of interest, how do you get most of your matters? Are they referrals or from word of mouth, or how does that generally work with a criminal lawyer?
Yeah, there's a lot of referrals. So you'll have a client and they're really happy. So a lot of my referrals are from people who are in custody. So they'll say, look, I've got a great lawyer, I'm really happy. And they'll say, can I put you on? Or we get a referral from legal aid who can put us into a matter, or I'm on the criminal panel from legal aid that sends me work as well. If they're not able to do that work within what's called in-house, if they don't have solicitors available, or it's got some complexity, it will take some time, they send those to private lawyers that are on those panels and are specialised in that area. So I've been doing that for many, many years. So I've been on those criminal panels with legal aid since I started practicing. So they're very hard to get on, I have to say. It's a bit of a challenge, but when you're on them, you can see why, because it's complex work that we do, and it's difficult work, and you can't get it wrong. You have to do a great job every time, because people are relying on you for their liberty, and it's something that you really need somebody who knows what they're doing.
Great. All right, Julie, well, thank you very much for your time here today to share some of your insights and also some of your insights on your professional wardrobe as a criminal lawyer. I've really enjoyed talking to you, and I look forward to speaking with you again.
Thanks, Paula. Great to see you.